Hello everyone. I hope this message finds you fit and fine. My name is Shashank Tyagi. Welcome you all to our contest series Indian Polity based on Lakshmikant. Today we need to talk about federal system in India. First, let's talk about this word federal, because this comes in news often due to some state-state conflict or state-center conflict. Have you ever taken sight of center? That how can state actually demand more funds from center? And you associate your political affinity with center. So if you do that, then this topic is important for you to understand how our political system is arranged. And in lieu of this arrangement, state governments make certain demands on center. And if these demands are specific to Indian context or these demands occur in other areas of the world as well, my friends, these demands are associated with the kind of political system mentioned in Indian Constitution or in their Constitution. Now, the word federal, this comes from the Latin word fidus, and this means treaty, agreement. But treaty agreement between whom? You can take example that consider these are some small areas. These are some small units, areas governed having certain government, but these areas lack some military might, economic prowess. And you know what happens if an area is economically or militarily weak? There may be attack from outside, right? And the people in this area may lose life, property. So now they may take decision to actually get under one unit. They can join together and form one bigger unit, and this bigger unit can be called center, and these small units can have different names. For example, in case of India, we can call them states. In case of Switzerland, they call them cantons. In Russia, they call them republics. Yeah, republics. And in case of Canada, they call them provinces. So it means there can be numerous names, but the context is some small units joining together and this bigger unit is being formed, right? Now, this bigger unit can be formed when these small units come together, as I gave you this example, or there can be another way. For example, there is a bigger area. Okay, bigger unit is there. For example, British India. Okay, and British India and their administration organized themselves into certain provinces as well. But at that point of time, when Indian Constitution was being framed, one big unit was sure. Okay, there will be one big unit, that is India, right? Now this big unit is also actually having this in mind, that let's organize our area into some small units. So it means these small units were created later. For example, Gujarat, Maharashtra, Telangana, Andhra, right? So these units were not organized in this manner during British time. They were organized later, right? So it means there can be this model also. Okay. Now, no matter which model we talk about, one thing is clear, that there are small units and there is big unit. Okay. And another thing is clear, that the small units have some list of powers in which they demand some independence. And this big unit also has some list in which this big unit is going to make laws, ensure important decisions are taken timely, right? So now one thing is clear, that this is independent unit in certain areas, and it is due to this relation we call them federal. And whenever center actually subjugate this small unit into these areas which are actually given to them to actually perform, then these states, these constituent units say that, okay, this is not federal. This is against the principle of federalism. This is against the principle of federalism as it was enshrined by our constitutional framers. Okay, so it means now the basic idea of the word federal and this concept federalism is clear to you, right? So among these allegations by different states, for example, Tamil Nadu was raising this point during this 15th Finance Commission, when this commission was about to give this recommendation. So Tamil Nadu government was saying that this recommendation and this formula might be against the interest of Tamil Nadu and certain southern states. So Tamil Nadu and the leader, Mr. M.K. Stalin, he was demanding that, oh, these states should come together and then they should raise this voice in front of center. And there were reports that certain political outfits were also demanding cessation from the Indian Union because 15th Finance Commission could have actually given formula where their interest could have been, you can say, subjugated. Now the point is, many people actually by reading this news, they plainly say, oh, this is unbecoming. Why states are doing that, right? So you take the side of center, right? Because you consider that taking side of center make you more nationalist, right? But my friend, nationalism is different, right? Because obviously, when it comes to secession idea, definitely you have to be, you have to take stand against it. But when it comes to states coming together against some financial decision, against legal decision made by center, right? And which they think is their prerogative, they should have been taken into, you can say, the loop while making this reason, then in this context, you should think that these are administrative, political decisions, right? And your nationalism will remain intact even if you try to understand the issues raised by states as well, because ultimate objective is welfare of the people, right? And that's why the both models of organizing regional units were made, right? Now, so scholars actually divide this system of governance into two parts. Means government we can divide into two parts. One, you can say federal government. Another, you can say unitary government. So here unitary, there's federal. So in case of unitary, as the word says, unitary, unit means one unit. So all the power is vested in this national government, okay, and the regional governments if they are there. But please understand, in unitary government, real power lies with national government, and if there are some regional units, then power will be given only by national government. It will be given, okay. It is not that clear division was initially chalked out, okay. But in case of federal government, we have some federal features in Indian Constitution, right? For example, division of power between center and state in Schedule 7 of Indian Constitution, where we have 3 lists, right? Union list, state list, concurrent list, right? So here we see national government and the regional government, they are actually operating in the respective jurisdictions independently, taking their power from these lists, okay? But here they derive the authority from the national government. Real power lies with national government, okay? I've told you about the difference between the models of government. It is not like in case of federal government, the model which we are seeing here is exactly the model which we have in India. We have a hybrid model. Even the word federal is not mentioned in Indian Constitution, okay? And the word we use for Indian model, as K.C. Viere uses it, he says quasi-federal, means not fully federal, not fully unitary. We have adopted a middle path here, okay, for considering the challenges in Indian context. So we have some examples in unitary: Britain, France, Japan, China, Italy, Belgium, Norway, Sweden. In case of federal government, we have US, India, Switzerland, Australia, Canada, Russia, Brazil, Argentina, right? So moreover, we are having federal government model, but we are not idealistically, right? And when I say idealistically, for that you need to understand the model which was adopted by world's first established federation, and that was USA, United States of America. Now, just take a look what thing is clear to you. Federation, you are clear with this definition, you are clear with this idea that is not mentioned in our constitution. Indian federal system is based on Canadian model. What does it mean? It means in our case, center is more powerful than state. So this model was adopted by Canada and we have adopted also. Okay, that is why we call it Canadian model. Now this federation can be made by two ways. One is integration. For example, after American Revolution, when United States of America was getting formed, it took a long while, right? But initially 13 states, they came together. Means integration happened. And why? Because they found themselves that we are militarily and economically not viable enough to secure our interest, and that is why it is better that we join together, right? So militarily weak, economically weak, backward, and they join together, that is integration. Then we have disintegration. What does it mean? A big unitary state, for example, India as a state. Now, India as a state has this power using Article 3 that we can actually carve out new states as well, right? We have carved out in this whole journey. So, in this case, the state status to a particular region is also given by the national government, right? So this is disintegration, granting autonomy to the provinces to promote regional interest. And this is the purpose. For example, Uttarakhand was carved out of Uttar Pradesh for what? For spurring economic growth, right? Jharkhand was carved out of Bihar. The reason was growth. Chhattisgarh from Madhya Pradesh, reason was growth, right? So it means here we are observing disintegration. Okay, and disintegration means breaking. Okay, example, Canada and India, there we call it disintegration model. Okay, so I think this is clear to you. Now attempt this question, and I find this question as direct, but there is some intricacy involved. Federal form of government power. Just attempt this question. You have 5 seconds to attempt. Power is vested in national government and state government. Power is vested in state government only. Power is vested in national government only. So by simple logic, most of the students, what they are going to do, they are going to remove these options. Yeah, these options are clearly wrong, right? And some students actually are going to mark A as the answer, because the word is power is vested in national and state government. So they will think, okay, yes, power is there. In case of India, power is there with state as well as national government, right? But this option is also wrong. The reason is, question is saying federal form of government power. So they can say federal form of government may be represented by which of the following statement. Sorry. So in this case, what you are going to do, you have to actually understand which definition actually defines this federal concept. So do you think if someone reads this, that person will be able to identify, yes, this is federal form? No. Because I told you now that in case of unitary government, there may be state, there may be region, and it may be possible that national government will give some power to the state government, right? So in this case, do you think this is directly connecting to the federal form? No. For federal form of government, there should be mention of the word divide, means division of power between center and state. Okay, these details you need to be clear about. So divided between national government and regional government, and both, since they have clear division of power, they can operate in their respective jurisdictions independently. Okay, I hope now you're not going to commit this mistake. Now let's compare federal and unitary features, and this is quite simple to even remember. Okay, UPSC asked one question from here: which of the following features can be represented as federal features, right? So now take a look. Dual government. It means there will be two government. One government at the center, other government at the level of state. Next, you can see written constitution. Now, what federalism has to do with written constitution? There's a reason to that. If constitution is written, then this will have a structure, defined power sharing between center and the constituent units, right? If in case this is not written, the whole power to decide what is going to be considered as constitution is given to parliament at the level of center, don't you think the rights of the constituent units can be subjugated at any point of time, right? So this clarity needs to be in your mind that written constitution is a feature of federal government, because if these features are clearly written, then there will be a clear clarity in the at state level. Yeah, these are the areas in which we have to work. We are safeguarded by constitution. Okay. Now, division of power. That is quite obvious. We were talking about this. National and regional government, they should have clear division of power. Supremacy of the constitution. Constitution should be supreme. It means no other organ of the government can supersede constitution, because it may be possible, parliament will try to actually take away the power of state. But this cannot happen in Indian context. Why? Because we have supremacy of constitution, right? There are provisions where actually parliament can actually make law with respect to state list. There are provisions, but this provision cannot be used arbitrarily. There's a logic behind it. If at any point of time parliament try to actually trespass into the prerogatives of state arbitrarily, that is not important for the national integrity unity. So in this case, what Supreme Court is going to do? Supreme Court will declare such law null and void. So that is why, because Supreme Court is the actually guardian of Indian Constitution. And supremacy of Indian Constitution is a feature. Rigid Constitution. Here rigid Constitution is related to amendability. Means it is difficult to amend Indian Constitution, and especially in federal governments, right? This feature is there. Because if amendability is easy, then at any point of time, the power dynamics, the area of working between center and state can be changed. So this need not to be changed. That's a promise actually center and state have to uphold between them, right? So that is why rigid word is used, okay? Means amendability is difficult. Then independence of judiciary, because only judiciary can actually ensure supremacy of constitution when center and state are in conflict, right? So basically independent judiciary is needful for this federal government for two reasons. There are two reasons. Number one, to uphold supremacy of constitution, right? One reason is that. And there's another reason. Second reason is Supreme Court, means in this case judiciary, is going to listen to the conflict between center and state and resolve the conflict between center and state, right? So legal disputes can be taken at the level of judiciary, and the state will go to the judiciary only when there's independence of judiciary, right? So do we have some features of independence of judiciary in Indian context? Yes, we do have. For example, fixed tenure, right? You have, when it comes to their salaries, you have security that their terms of engagement cannot be changed during their tenure, right? So this represents independence of judiciary. Judiciary has independence with respect to the financial needs they have, right? In Parliament chapter, we are going to discuss this. What is the difference between charged on consolidated fund of India and what factors can be voted? So safety, you can say independence is given to judiciary. That's a feature of federal government. Bicameral legislature. What does it mean? We have two levels at the level of parliament, two houses, Lok Sabha and Rajya Sabha. And the Rajya Sabha word itself represents Council of State, right? So my friends, you should know this fact that when federalism as a concept was evolving in West, so it emerged from this idea that small units should have some say in legislative body at the center, small units should have say in legislative body at center, because Lok Sabha actually represents will of people when whole of India is taken into consideration. But when it comes to state specific issues, we need a separate body, separate house, that is Rajya Sabha, right? And in case of India, we have representations given to a state in Rajya Sabha based on population, and this representation varies from 1 to 31. Right? And this is difference because in case of India, how many seats a particular state is going to have in Rajya Sabha depends on the population you have, right? There's no equality in representation with respect to, states. But in case of America, their federal model is such that in US Senate, every state is given 2 seats. No matter how much population you have, no matter what territorial area you have, 2 seats. And that is why the seats are 100. Because 50 states they have, and then independent area Washington DC, right, district. So this is the difference between American and Indian model. But bicameralism is a feature of federal government. Please remember that. Okay. Now, when it comes to unitary government, it is quite easy to remember. Just take a look that we were so actually clear about this. Yeah, these are the features which are needed for federal government, right? In case of unitary, there's a mix. Means maybe written, maybe unwritten, maybe rigid, may not be rigid, maybe supremacy of constitution, may not be supremacy of constitution. Take a look. Unitary government, single government is there, right? Real power lies with center, and center may create regional government. They may give some power to them, but power is coming from the center. Constitution may be written and may be unwritten. For example, France written and Britain unwritten. Both have unitary government. No division of power. Means all power are vested in the national government, but here we have division of power. Constitution may be supreme, may not be supreme. For example, constitution is supreme in Japan, and constitution is not supreme in Britain, because in Britain parliament is supreme. Parliament is deciding which law is going to be considered part of constitution, right? Constitution may be rigid, may be flexible. In case of France, it is rigid. In case of Britain, it is flexible. Judiciary may be independent, may not be independent. Legislature may be bicameral, may not be bicameral. For example, unicameral in China, bicameral in Britain. So it means you should remember the features of federal government. You should be clear about the concept, right? The logic behind them. And here, in case of unitary, you can consider maybe. Okay. So I think it is clear to you now. Now, why India adopted federal system? 2 major reasons. First is our geographical experience. Means our large size, right? In large size, to manage it, there may be some regional aspirations in this area which may be different from this area. So if we divide some power between center and this area, so it would be better for the people of these areas if their regional aspirations can be heard at the level of state as well. If there are some national aspirations that can be heard in Lok Sabha, regional aspirations can be taken into consideration at the level of state as well. Right? Social cultural diversity. If social cultural diversity is such, then it means we should actually divide the power into different regional units, right? Now, Article 1, it describes India's state as a union of state. There's no mention of the word federal, and connotation is that meaning is that India is an indestructible union of destructible state. So what does it represent? It means although we are actually having union of state, it means we are talking about a federal model, but the power is tilted towards center. Union of state has been preferred over this. Indian Federation is not the result of agreement. We're not result of agreement, right? Because India as a state was created, and then India as a state was actually making that, yeah, these states will be there. Because American Federation was actually a result of an agreement that some states were coming together. But here, we're not coming together. So there are 2 models, coming together, holding together. We're not coming together, right? We are holding together, and we were carved out. The states have no right to cede from the federation, right? Federation is union because it is indestructible. Now, features of federalism, those features which we have discussed, I've just given representation here. Now, unitary features means in case of India, we have federal features, we discussed it, right? Now, we also have some unitary features. For example, integrated judiciary. Supreme Court, High Court, and then lower courts. Integrated judiciary is there, right? A strong center is there in India. What does it represent? Unitary features, right? There are areas where center has more power than state, right? States not indestructible. Article 3. States can be divided, and state can be divided and by parliament, and state will not have any, you can say, any power to stop that if we talk about state legislature, because such bill will be given to state, but their recommendation or their apprehension is not binding on parliament, and this state can be divided by simple majority. I told you in Article 3, Article 4. Single constitution is there. We don't have the system that state can have their own constitution, right? In US case, they have. Single citizenship is there. You need to be citizen of India. You need not to be citizen of other state, right? Flexibility of the constitution. There's amendment procedure, and in a case of amendment can be done by simple majority. In some cases, as I gave you we'd had this discussion in amendment to Indian Constitution part, and I gave you example in Article 3, Article 4, right? Apart from this, there are some amendments in which state assent is not needed, right? Emergency provisions are there, Articles 352, 356, 360, and when they are used, the power dynamics between center and state, they actually get tilted towards center. So it is a unitary feature. No equality, as I told you. In case of Indian Rajya Sabha, we have 1 to 31 seats based on population they have. But in case of US, they have this concept of equality, 2 seats per state, right, in their Senate. So now critical evaluation of the federal system. It means, what are experts' opinion on India's federal system? Take a look what K.C. Vere says. He says, India is not completely federal. India has unitary features and these subsidiary federal features, rather than a federal state with a subsidiary unitary features. Okay, so it means if we have to decide between federal and unitary features, we have more unitary features and subsidiary federal features. Okay, so you can use this statement in your mains answer. So that's why he used this word, India is a quasi-judicial state, a quasi-federal state. You should use the word federal. Quasi-federal means that we are not completely federal. We have adopted a golden mean path. Okay. Now, according to K. Santhanam, India has practically functioned as a unitary state. It means both observations are talking about unitary feature. Though the Indian Union states have tried to function formally, legally as a federation. That we have Rajya Sabha, we have setups in which state upholding the laws made by center. We have this finance commission deciding, giving the formula, recommending the formula of division of financial resources. So it means K. Santhanam is saying, yeah, legally we have functioned as a federalism also, but still we should know that we have unitary features. And why we were having unitary features? Because of the challenges which constitutional framers were observing in India. The challenge of secession, right? Now, Paul Appleby, he says that Indian system is extremely federal. He says that there is division of power. Morris Jones termed as bargaining federalism. Bargaining federalism means now state governments, because they have their political, they can have their political might in center as well. On this basis, they actually bargain with the center. For example, regional parties, when regional parties, they are supporting the coalition at the center, they say we are going to support only when you give 10,000 crore package, a special package to our state. So this kind of bargaining also happens in Indian federalism. Granville Austin says Indian federalism as a cooperative federalism. It means center and state have a lot of areas where they both cooperate. For example, Niti Aayog, GST Council. It means in GST Council, both center and states are there, right? And they take part into decision whether what should be the GST slab, right? And Niti Aayog, when it comes to big ideas, it is Niti Aayog which actually take into consideration the views of states, check the practicability of those ideas and give recommendation to the center if such policy can be made for that state. So it means Granville Austin cooperative federalism can be seen here. So in Bombay case, Please remember, Bombay case was related to misuse of Article 356 by Union, where state governments were toppled for political gain using Article 56. So Bombay case clearly said that no, this misuse of Article 56 should not happen, and just federal system, federalism is the basic structure of Indian Constitution. Okay, so whenever it comes to federalism question, you can quote Bombay case establishing federalism as the basic feature of Indian Constitution. Okay, now do we know some trends which actually represent that yes, in Indian political system there is federal spirit? So you can clearly remember them. For example, we have territorial dispute between states. So if territorial disputes are there in between state, it means they recognize themselves as independent political and administrative unit. That is why they are having this conflict, right? We have conflict on water issues, water sharing. We have this emergence of regional parties, and these regional parties actually showing influence in Lok Sabha as well. We have creation of new states, right, on this agenda of development. We have this more financial grant demand by different states. We have this assertion of autonomy of the state, that they want more power. They need certain areas need to be given more, you can say, more authority. So what does it represent? It represents that at the regional level, political and administrative unit has this consideration that there are areas in which they are independent from the national government, and this is called federal spirit. I hope you are clear with the concept now, right? Now attempt this question. Which of the following are recommendations by Sarkaria Commission? You should remember Sarkaria Commission, Punchi Commission on Center-State Relations. So you should just go through the recommendations made by this Sarkaria Commission, and you can quickly use these points whenever a question is asking you to have arguments on center-state relations. Okay, so if you go through them by recommendation, you will be able to understand the issues as well. Okay, so just take a look. What do you think? A, B, C, D, all four. So answer is all of the above. Okay, so these are the recommendations of Sarkaria Commission. So I hope now things are clear to you about the idea of federalism, right? In our previous video, we were discussing about concept of federalism, how it evolved, and what kind of form of this concept of federalism was adopted for Indian polity. Today's topic, center-state relation, is an extension of previous topic. We need to understand the basis of relation between center and state. In federalism, we use the word division of power. So you can say, today we need to understand this division of power in these three heads. Today we are going to focus on legislative aspect. Okay, but in this topic we need to understand these three heads. First is legislative head, second is financial, and third is executive. In center-state relations, we don't talk about judicial or judiciary as a basis of division. The reason is, in India we adopted integrated model of judiciary. But in case of US, they have division between federal government, state government on the basis of judicial as well. But we don't have that. We have only three areas of division of power. Okay. This division is clearly mentioned in our constitution in part 11 and part 12. And the kind of questions UPSC is going to ask, number one, there can be a statement based on some fact, part, provision. Okay. Second statement could be on exceptions within the center-state relations. Okay. And third can be if there is some legal dispute going on. There are some claims made by a state that this law is not the prerogative of center. But this became a news. So one statement can be from that area. Okay. In case of mains, you can have one question where UPSC is going to check your understanding of these provisions. Second question can be dynamic, where you have to infuse your static and dynamic knowledge. Okay. There are good amount of trap questions which can be made from this topic. So if you are cautious while watching this video, I will request that now you should become extra cautious. Have a pen and paper in front of you if you can. If you're traveling, then that is fine, because we are going to have some tricks and tips also here so that these things get concussed in your mind. Okay. Now, legislative power. So these are mentioned from Article 245 to Article 255. And there are 4 aspects of division of legislative power. Okay, what are the 4 aspects? Number 1, territorial aspect. Means state legislative power is going to have extent to which territory. Center means parliament is going to have influence on which territory. Some of you might be thinking, oh, it's quite obvious. Parliament is going to have the whole of India and state legislature is going to have specific to that state territory, right? That is what you are thinking. There are 3 cases in this. Number 1, Parliament can have this law-making power to the whole of Indian territory. Second, to a part of Indian territory. Third, beyond Indian territory. Now tell me, which of the 3 aspects with respect to territorial legislative making power of Parliament are true? Think and just mention in comments. As of now, I have no expectations, because I'm considering that you are just starting off. Okay, at later point, I'm going to have expectations from you. But just answer. Some of you would say, sir, it is quite obvious that Parliament can make law for all of India or part of India. How can Parliament make law for territory which is not part of India? But my friends, answer is all 3. So it means you should not take this topic lightly. Okay. Now, subjects, the division of subject between center and state, that we are going to discuss when we are going to discuss Schedule 7. Okay. Today we are going to deal with legislative aspects, all kind of questions, dimensions which can be asked. Now, third aspect is Parliament's power to actually make law on subjects which are considered as state subjects. Fourth aspect is center's power to actually have control on state legislature. What does it mean? It simply means, consider that you are governor of Uttar Pradesh. Okay, no, take yourself as governor of Rajasthan, because in Rajasthan we have a Congress government. So now Congress state legislature, they actually passed a bill, and this bill has been presented to you. You are governor of Rajasthan. Okay. Now, it may be possible that you see, oh, this provision is having some conflict with center, a law made by center. And that is why you reserve this bill for the assent of Honorable President. So when Rajasthan legislature, Rajasthan CM was expecting, oh, now Honorable Governor is going to sign this bill and this will become act. But you took other course. You sent this bill to the Honorable President. And you know that Honorable President has to act on aid and advice of Council of Ministers. And who is the majority party there? Who is the ruling party? BJP, right? So it may be possible they say, oh, no, this is in contravention. So now, don't you think center means here Council of Ministers advising President is having control on legislative power of state legislature? You can say legislative power of state, right? So these are the 4 aspects in which we have to understand legislative relations. I hope this is clear to you. Just remember these areas. That's it. Okay. Now, territorial extent of center and state legislature. Number first, Parliament can make law for whole of India or any part of India. Okay. Along with this, Parliament has one more power, that is extra territorial power. And this power is only with Parliament, not with state legislature. Please remember that. Okay, there are 3 cases of territorial law-making power of Parliament. Clear? When it comes to state legislature, it can make law for whole of state as well as for part of state. For example, Madhya Pradesh legislature may make a law which is going to be applied for only 2 districts. If conditions are such, they can apply this law for 2 districts. Okay. Parliament alone has this power, extra, territorial. When I'm using the word territory on which Parliament is having power, what does it mean? It means the definition of territory which we discussed in part 1. It means all states, UTs, as well as all the territories which are acquired, okay, acquired by India. I find a beautiful scope of question here. Just listen to me. What if UPSC make a statement that Parliament's power to make law absolutely extends, Parliament has this absolute power to make law with respect to whole of territory of India, which include all states, all UTs, and other territory which may be acquired by Indian state. Now tell me, the statement would be true or false? And mention in comments. Those who are watching this video, just mention in comments. Should I repeat? I'm saying Parliament has this absolute power to make law with respect to whole territory of India, which include all state, UTs, and other territories which may be acquired in future. The statement is true or false? Come on, in comments. Because my purpose is to actually reduce any scope, eliminate any scope of you marking wrong answer in exam. And that is only possible when we actually have maximum accidents within this class through these trap questions. So some of you might be thinking, sir, it is quite clear from the statement, can make law for whole or any part of India. So whole means whole. The statement should be true. And 98% students who have read this chapter for say 1 or 2 times and missed on understanding the detail, the intricacy, will mark wrong. Because answer is not true. Answer is false. Because the word absolute was used in the statement. Absolute power. Absolute power nahi hai. Okay, because there are exceptions, and within the start of the video I told you that UPSC will play on these exceptions, and we are going to cover this, all of this, don't worry. But answer is no, and answer is no because absolute power is not there. There are exceptions as well. Okay, what are those exceptions? Let it be a bit of suspicion there. Okay, not suspicion, suspense. Okay, now laws of Parliament are also applicable to Indian citizens and their property or any part of the world. That is a part of extraterritorial. There's a famous case in here. Wallace versus Income Tax Commissioner, 1948. Okay, this is related to extraterritorial legislation. So what was happening in this case? There was an England-based company, and this England-based company actually made a partnership with an Indian company. Okay, so now Income Tax Commissioner sent a letter to this England-based company that you have minted majority of profits from India and you have partnership here. So that is why my assessment says that you have to give this additional amount as income tax, in this case corporation tax. So as a reply, this company said, no, you are using a law which was made by Indian Parliament. This law is not applicable in my territory. Now judgment came, and judgment said, if there is territorial nexus which can be established, it means the claim which Indian state is making in other territory is connected to Indian territory. Then in this case, yes, this England company has to pay this additional tax to India, because as per Indian law, the tax is right. Okay, but you have to do this test of territorial nexus. I hope that this is clear now, right? So in this case, what is happening? Extraterritorial legislation is in place, right? This law is being applied to other territory also, right? But this power is also not absolute. The test of territorial nexus should be made, right? Now, what are the restrictions? I told you, exceptions are there. Just take a look over these exceptions. President can make regulations for peace, progress, and good government of 4 union territories. It means the laws of parliament not applicable in the following areas. And in which area? These are the area. When I say area, it means peace, progress, good government. In this case, president's regulation will supersede any law which is made by parliament. And I find beautiful scope of question from there. Now, it is quite easy to remember which UTs we are talking about. It is not applicable to all UTs. Please remember. Only applicable to Lakshadweep, Andaman and Nicobar, and D square. D square means Dadar and Nagar Haveli and Daman and Diu. Okay, Dadar and Daman. Clear? So there are 4 areas which can be considered as exception where president's regulation will supersede a law made by parliament. Important, I would say. So when UPSC asks this question and you answer it correctly without falling into trap, then you can connect with me at later stage. Yes, sir. That advice actually worked. Now, second case. The governor is empowered. So governor is empowered in what context? In context of scheduled areas. So what can they do? It can direct that an act of parliament does not apply. So even if a parliament has made a law that I am parliament and this law is going to apply in whole area, all the territory of India, then governor for some state may actually present a regulation, and in that regulation governor will say no. Even if this is a parliamentary law, but it is not going to be applicable in the scheduled area. Okay, so it's a limitation on the you can say application of law of parliament, right? Third, in case of governor of Assam can do the same thing for tribal areas. Okay, apply to tribal area, or you can say autonomous district. So why we have this separate point 3 here? The reason is the provision of autonomous districts are there. There may be a case that there are scheduled areas, but in these scheduled areas, we have not given them autonomous power. Okay, so in that case, you have to apply article in this subclause 2. Yeah, point number 2. But it may be possible that due to the demand of these tribals, we have given them autonomous district status. It means when you become a civil servant and you are posted in this area, so you will have a district council. You will be having the core authority, but to support you, there will be a member from this tribal community. Okay, so this is a step towards inclusiveness. Okay, now another is president enjoy the same power with respect to 3 states. Please remember Meghalaya, Tripura and Mizoram. You can remember MeTM. Clear? I hope it is clear. Please remember these exceptions. Nowhere I have mentioned, in this case, I have not mentioned Arunachal Pradesh. I have not mentioned Nagaland. Okay. Although these areas, specific areas, say scheduled area, they can be covered by the governor. But in case of that, the power of governor is there to supersede a law made by parliament. But in this case, in the case of 3 states, president enjoys this power. Okay. Now, distribution of legislative subject. So first was territory, second was subject. So now we are at subject. So there are 3, you can say, list in schedule 7. Union list, concurrent list, state list. Union list, which is the, you can say, the largest list having 100 matters there. Concurrent list means in these areas, state and center, means union and state both can actually make law, right? And the state list in which a state legislature is going to have power. What kind of questions you can expect? Just go through the subjects on which union has power to make law. But don't think that UPSC wants you to remember all 100, 61 and 52 subjects mentioned here. No, there's no need. if a question is asked on match the following or a statement mentioning that this is a prerogative of union, this is mentioned in union list, then UPSC might ask question only on those subjects which were very much in news. For example, in COVID times, health management was in news, right? So who has the major responsibility to take care of the public health system? Is it center or state? It becomes a topic. Education, citizenship due to CA. So it means UPSC wants to check whether you are aware and whether you are interested, curious enough to connect the current happenings with the, you can say, structure which is mentioned in Indian polity. Okay, this is the approach which they are looking for, as per my analysis in past, around 7-8 years. Now, the power to make laws with respect to residuary subject. Now, what are the residuary subject? It means those subjects which are not mentioned in any of these lists. So, in this case, the power will come to union. Okay. In case of concurrent list, if law is made by both union and state, what is going to happen then? If there's a case of repugnancy, coming new means union and state law coming into conflict, then in this case, law made by union is going to be considered superior. Okay. But there's a you can say twist here. Some students, when they read Lakshmikant and they see, okay, in case of repugnancy, union law made by parliament will supersede. But on practical grounds, we have so many examples. This led to a conflict which was heard in Supreme Court, and Supreme Court used this doctrine of harmonious construction. Means Supreme Court made an interpretation by which both laws can work. Conflicting provisions were interpreted in such a way so that this conflict can be diffused. So such thing also happened in practical terms. Okay. Now, if we compare Indian, division of legislative subject in center state with, say, USA. So in US Constitution, there's mention of federal subjects. And since just federal subjects are mentioned, what it signifies? The interpretation is that residuary power lies with state. So there, residuary power lies with state. Any matter which is not specifically mentioned, state is going to make law. But any matter which is not mentioned, union is going to make law in context of India. And with Australia as well. In case of Australia also, this residuary power lies with provinces, means states. Okay? So there is a difference. Now, this is fact that union list 100 subjects, state list 61 subject, concurrent list 52 subjects. Okay? Both parliament and state legislature can make law on these subjects. I'm talking about concurrent list, I told you. But in case of conflict between union and state, regarding subject, union law prevail over the state. I've just told you. And I also added one practical example of doctrine of harmonious construction. Now, third aspect is parliamentary legislation on the state field. Okay? What we are doing actually, we are going with the structure. I told you there are 4 aspects. Out of this, we are on third. First, second, now we are on third. Means parliament having say on the legislative power of state legislature. So how can this happen? In this case, Rajya Sabha's role come into being. Because Rajya Sabha represents state interest. It is considered at least. So the constitution empowers the parliament to make law on any matter in state list. Please remember, any matter in state list. But what the condition is? 5 extraordinary circumstances. In 5 extraordinary circumstances, please remember, parliament can make law on any matter in state list. Number 1, when Rajya Sabha passes a resolution in this regard, means there's a matter of national importance and this is in state list, and Rajya Sabha says, I'm representing state and parliament, and that is why we are conducting a resolution and we are passing this by special majority. Special majority means 2/3 of present and voting in this case. Okay, so then resolution remains in the force for 1 year. It means any law which is made in this regard, means which is made on matter mentioned in state list will be in force for at least 1 year, but it can be renewed any number of times. Please remember, any number of times. UPSC play on these things any number of times. Okay, but it should not exceed 1 year at a time. For example, if you have made a law based on matter mentioned in state subject, then it will apply for 1 year. After 1 year, you have to bring this resolution again and then extend it for another 1 year. And you can do this process any number of time. Okay. Now, laws cease to have effect on expiration of 6 months after the resolution has ceased to be in force. Which resolution we are talking about? This resolution. Because consider this resolution was extended to 1 year, and 1 year extension is say 1 January 2023. Right? On 2023, this 1 year of this resolution will complete. Okay. Now, Parliament has a choice whether to extend this resolution, but they have not extended this resolution. Now, from 1 January 2023 to 6 months, just for 6 months, this particular law will be in place. Okay. Although it can be repealed before that as well. Right? But if it is not repealed, it can actually go on for 6 months, and after that it will be considered expired. Okay, this is the meaning of this particular statement. I hope it is clear now. So this is the first case, first extraordinary circumstance. What is the second? Second is during national emergency. Okay, laws become inoperative on the expiration of 6 months. So it means if national emergency is in place, now legislative power of state comes to the center. Because now it is a matter of, sovereignty, integrity of India becomes topmost priority, right? But as emergency is done, after that, till 6 months, this will be in operation. These laws can be in operation, and after that, they will cease to actually, exist, right? So now, are you observing that although power is given to Parliament in extraordinary circumstances to make law on state subject, but our constitutional framers have given some safety wall also, right? So that states' power remain intact, so that concept of federalism can be visible in Indian polity. Okay, because independence of state is being ensured by providing these safety walls. Now, when states make a request, what does it mean? If two or more states request that Honorable Parliament, we want you to make law on this topic, although this is a matter of state subject, but we want you to make law. So in this case, what Parliament is going to say, okay, if you are willing, then we are going to do that. So in this third case also, law enacted and applies only to those states, not to others. Okay, because 2 and 3 states came, right? They may be states which are ruled by the same party which is in power in center, right? So it is not going to be like 3-4 states ruled by the same ruling party in the center. They come and say, sir, make law on state subject as well, and now Parliament is empowered to make law for all the states. No, it is going to be applicable only to those specific states. Any other state may adopt it by passing a resolution to that effect in their legislation. Okay, that is their raza. वो उनकी रजा है. If they want, they can do that. Okay. Fourth, to implement international agreements, for example, Geneva Accord, Vienna Convention, TRIPS, trade-related intellectual property rights. So when we apply these international agreements, sometimes what happens, some aspects are mentioned in state subject, for example, related to trade. So in that scenario, Parliament can say that although matter is in state subject, but to uphold this international agreement, we are making this law and this will be applicable. So this will be applicable. Okay. Fifth, during President rule, a law made by Parliament continue to operate. I'm talking about Article 356, right? If constitutional machinery is broken and on this basis President rule is imposed, so now Parliament will make law in this regard. So although rule is President rule, but Parliament will actually make this law. Okay, but it will be there. And consider that after say 1 year, President rule cease to exist. So this law, which was made by Parliament for this particular state where President rule was imposed, will continue. And continue till what time? Till it is removed or altered. such a law can be repealed or altered or reenacted by the state legislature. But after this president rule is removed, now power will come to state legislature. Now this will be choice of state legislature. Okay. So there's no case of this 6 months expiration. Okay. Now just attempt this question. When the legislature of 2 or more states requests the parliament to enact a law on matters of state list, that law repealed or amended by state legislature, amended, repealed by prime minister, amended, repealed by parliament, amended or repealed by governor of that state. This is a good question, because in our discussion, when we are talking about the case of 2 or more states requesting parliament, so we just discussed that yes, parliament can make law in this regard, and this law will be applicable to these states. But what about power to amend law, power to repeal law? So if law is made here and it is applicable to these states, now power to amend this, change this law, will be with these states or will be with parliament? Right? This is the question. Although they have requested this, they want this law to be applicable for them. Does it mean that they have also given up the power to amend and repeal that law to be applied on them? Or just mean that they just have asked parliament to make law, and the later function of amendment and repeal they can do? So this is, I find this is a beautiful scope of question. What do you think? Mention in comments. Answer is C. Why it is C? Amend and repealed power will be with parliament, because parliament has made the law. When you have requested parliament to make law in this state subject matter to be applicable to you, at this point of time you have given up your power with respect to that subject, with respect to that law. Okay. It's not like you cannot make any law on that state subject now. No, you can make other law, but for that law parliament is going to have power. Okay, I hope you like the twist. Now, center's control over state legislation. As I told you, certain bills, reservation of certain bills to the by the governor for the consideration of honorable president. Gave you the example of Rajasthan. Certain bills require prior presidential sanction. So in this case also center has control, because president is going to act on aid and advice of council of minister. President can direct to reserve money bills and other financial bills during financial emergency. So in this case also president is actually having control on state's legislative power, right? So I hope now all these 4 points, 4 areas of legislative aspects of center-state relations are clear in your mind. They should be context now. In our previous class, we were discussing center-state relations, an important topic. And we know now that we can divide this into 3 heads, means legislative aspect of center-state relations, then financial, and then executive. We have gone through legislative aspect, and today we need to talk about administrative or executive aspect of center-state relations. Good number of questions can be made in your upcoming prelims, so give due attention. So these relations are mentioned in part 11 and part 12 of Indian Constitution. This is a factual information. Now, Article 256 to Article 263, they deal with administrative relations between center and state. If we talk about the basis of categorization, we can say majorly theme is same as we learn in legislative aspect of center-state relations. What does it mean? It simply means that in case of legislative power, there is Schedule 7, clear division between union, state and concurrent list. So based on these themes, we have delegated or given executive power to center and state, right? So it means theme is same as distribution of legislative aspect. Center has exclusive power on union list. I'm talking about legislative aspect, okay? Because on this basis we have executive. The state has exclusive power on state, and when it comes to cases like making law for implementing any international treaty agreement in that aspect. Even if the matter is in state list, center can make this law. We discussed this in previous class, right? With respect to concurrent list, both center and state can make law. Now, please understand, in executive aspect, we are not going to use the word parliament and state legislature like we were using in previous class. Now, we need to use the word central government because our focus is executive. Legislative is there to make law and executive is there to implement law. And there are two kinds of executives, permanent and temporary. So those of you who are preparing for civil service exam, considering all of you are, so you are preparing for permanent executive, and there's temporary executive also, ministers who have to give exam after every 5 years or even before that if their government falls. Now the point is, when we say executive power, whose power we are talking about? We are talking about all executive branches which are there at center as well as state. Now just take an example. Say Ayushman Bharat Yojana, a scheme conceptualized by central government. Now tell me, can central government implement this scheme without cooperation from state government? Because when it comes to health department at state level, they come under state government. Because we have central departments as well as state departments. For example, income tax department. So those officers who are working there, they are permanent executive, but they are part of central government. They are there to implement a central law. For example, income tax law, which is applicable all over India. They are there to implement that. For example, health. Health is, say, health department is under state government. So now why I'm raising this question? I'm raising this question to let you know that in case of executive power, cooperation is necessary. You can say it is mandatory. Without cooperation between executive, whether center and state, with respect to implementation of these policies, no policy will actually see the light for which it is made, right? So it means cooperation is necessary. So when it comes to central government, it has power to execute policies on subjects which are mentioned in union list. And that is why we were saying that yes, there is similarity between distribution in legislative nature and executive nature, right? In case of state government, they have power with respect to state list. It means matters mentioned in state list, if there are some laws, then these laws need to be implemented. These policies need to be implemented by state government. I hope you're getting clearer, right? Executive power does not mean that state government is going to make law on state list, because we are using the word state government. Okay, when we talk about making law, we should use the word state legislature, which we used in previous class. Okay, so there's difference. Now the point is, what about concurrent list? Means state list is clear, union list is clear division of power is there. But in concurrent list, in legislative aspect, we discussed that law can be made by both center and state. What about the executive power? Executive power lies with center or state? What do you think? What's your guess? So some of you might be thinking, sir, in concurrent list we discussed that priority is given to law made by union legislature, means parliament. That is what you discussed. That is what we discussed, right? Can you say this is the same theme when it comes to executive power? No, there's a difference here. Just remember from this particular analogy, in case of union list, power is with central government, executive power, state government. When it comes to concurrent, state and center both have power to execute that law, but priority is of state. Now, what does it mean, priority? It simply means that when it comes to concurrent list, the executive power rests with the state until and unless there's a specific mention in that law that, okay, the implementation part of this law will be with center. So if there is no mention with the law that who is going to implement this law, then it is going to be responsibility of state executive to execute that law. I hope you are clearer now. So I feel that there can be a question on this. It's a star point. Okay. So there's a difference there. Now, in legislative aspect, we also discuss residuary power. It means law-making power on subjects which are not mentioned in any of these three lists. So we discussed that in case of residuary power, power lies with center, right? Means parliament. And I also gave example of USA and Australia, right? Now, in case of USA and Australia, we discussed that residuary power lies with state. But in case of India, residuary power lies with center. We have strong center. Canada has strong center. In case of Canada also, residuary power with respect to law-making power, it is with center, right? Now the point is, what about executive? Why we have not mentioned executive power with respect to residuary? My friends, the word residuary is used in law-making context only. Okay, that is why in executive we have not used it. Because residuary means this subject is not mentioned in any of these lists. So if something is not mentioned, first step is to make law, right? But here we are talking about law making, we are talking about implementation of law. So consider that center has made a law, because center has the this residuary power. Then it's quite obvious that for implementation of that law, there will be mention that which department, which level is going to be responsible for implementing that law. So there is no debate with respect to residuary power here, right? Clearly, if center is going to make, then definitely central government is going to have power. Okay, I hope this is clear. Now, as we start in executive power from Article 256, so first question is, what Article 256 says? क्या कहता है? So there are 2 points which are mentioned in Article 256. First point is that state has to comply with central laws. Means state, while exercising its executive power, cannot contravene central law. So it means opening article of executive aspect of center-state relation gives primacy to center, that state, you cannot do this. Okay. And the second clause, I told you there's 2 points here, na? Clause 1, subclause 2. Now, second point says that center can give necessary direction to the state for this purpose. It means a state should uphold the central law. Executive actions of the state cannot contravene central law. So that first subclause says the state has to take care of this. And subclause 2 says if state is not taking care of this, then center has this power, the center can give the necessary direction. Okay. Now, what if a state don't comply? What is going to happen thereafter? So Article 256 do not mention, you can say Article 256 is mute on punishment, or you can say action. We should use the word action. What is going to be the action thereafter? So the Article 256 is mute on that. So why mute? Because Article 356 clearly give action power to the center. What action power we are talking about? Coercive sanction. It means state government can be actually, it can be said that since Article 256 said that you cannot contravene any central law, you have to uphold central law, then if you are doing this, then this can be a ground of imposing president rule, that the state is not working as per constitutional provision. But this power is mentioned in Article 356, constitutional machinery part, and clearly with respect to this direction word is mentioned in Article 356. Now we are using the word coercive sanction. What is coercive? It means that you don't want something, but still that thing is being done with you. That is coercive, right? Now there are 4 cases clearly mentioned where coercive sanction can be used by center, and they clearly tell us the executive relation between center and state. So I feel that there can be a good question from these statements in upcoming prelims. Means a good question can be made. Number 1, the construction and maintenance of means of communication by the state, means such direction can be given, because Article 365 says that direction can be given by the center to the state, and if state does not comply, then this state can be declared that there will be president rule there, right? So 4 kind of directions. First, construction and maintenance of means of communication. Please remember, the word is construction and maintenance. It is not just maintenance, okay? If UPSC make a statement that as per Article 365, the necessary direction to the state can be given with respect to means of communication only for maintenance. So no, it's for construction and maintenance, because devil is in the detail. You never know at what deeper level UPSC play with you. Now for the protection of railways within the state, please remember it mentions protection of railways, because we have railways department at center which is responsible for construction of railway line. Construction of railway line is not done by state. So that is why direction will say we have built these you can say railways, and now you have to protect, right? So it means construction as a term for this direction is not there. This is just for protection. Clear? Now third, facilities. And facilities for what? There are 3 points here. Facilities for what? Mother tongue, means instruction in mother tongue, okay? Second, primary stage, means instruction in mother tongue, primary stage, and for linguistic minority groups, okay? So it means if center is giving direction to the state government that you have to provide facilities to give instruction to the children who are studying at primary stage or eligible to study at primary stage in their mother tongue, and specifically talking about linguistic minority, because it is their right to get educated in their mother tongue. So in this case, if a state does not comply, then it will be considered as a base for applicability of Article 365, okay? So such is the sensitivity or importance of this particular provision, okay? Now fourth, for execution of specified schemes, please remember the word is execution, not formation. Execution of schemes for welfare of scheduled tribes. So it means if center gives a direction to the state government that we are giving this direction that you have to make this scheme, you have to make a scheme for scheduled tribes welfare, and if state doesn't comply, do you think that can be considered as a base for coercive sanction under Article 365? No. Because state government will say, why you are not making a scheme? You have a dedicated Ministry for Tribal Affairs. You can make the scheme. Why you're not? So here the word is execution. A state has to execute. Okay? Although state can also make, but that is state's will. But center can give direction in the case of execution of that scheme. I hope all these 4 points are clear to you. If a question is asked, it should not be wrong from your point. Now, cooperation between center and state. As I told you, with respect to executive, relations, cooperation is necessary, right? So there's Article 261. It says full faith and credit. It means whether there's a law made by center, law made by state. Because even if a law is made by center, execution is going to be done in one or other state, then don't you think that executive machinery of state has to respect the implementation of this law which is made by Parliament, right? And this can only happen when there is full faith and credit throughout the whole territory of India, right? So this is clearly mentioned in our constitution. So it means public acts, judicial proceedings, center and every state, they should be given they should be received with full faith and credit. Okay, if they are not being, you can say, received in this manner, then it will be considered as an unconstitutional act by that particular department, and actions can be taken against the department, right? Because it is unconstitutional. When I say unconstitutional, it means you are standing opposite to what is mentioned in our constitution. Okay, Article 262, what it says, Parliament can provide for adjudication, means if there's a dispute with respect to distribution and control of waters or any interstate river or river valley, so in this case Parliament can actually provide for adjudication, means mechanism can be developed by Parliament. Okay, Article 260, please remember Article 262 is talking about dispute related to water, interstate water, river valley. But when we say Article 263, it is having provision with respect to any kind of dispute. What it says, President can establish an interstate council to investigate and discuss subject of common interest between center and state. So it means in interstate council, there can be a possibility that two states are having opposing views on a particular point. Before it becomes a dispute, open dispute, it can be resolved with proper talk and proper, you can say, coordination, and arriving at a particular decision and then executing that decision. So you need a dedicated body for that, and that body is Interstate Council. Okay, so such a council was established in 1990. That's a factual information. Now, public services, as I told you, executive, temporary, permanent, and you have to be part of permanent. So these departments are being run by officers and other staff, right? So where we have three kind of services which we call public services: state services, central services, all India services. When I say state services, it means people in the service are recruited, trained and deputed by state government only. For example, a particular state government organizes this state PCS exam, provincial civil service exam. So people, by passing this exam, they also get the position of deputy collector, SDM and DSP, right? But definitely when it comes to promotion and the seniority, they are considered, you can say, at the secondary position in comparison to central service and all India service. Okay, what is common in central service and all India service? The people for them are recruited, trained by center. Okay, I have not used the word deputed or working under, because in state service they have to work under that specific state government, right? But in case of all India service and central service, what is the difference? For example, income tax department. So some of you get elected, so some of you actually, when you were filling your choice in detailed application form, so as per your choice you got IRS, IT, means Indian Revenue Service, income tax. So you have opted for central service now. Your recruitment is done by UPSC, you are going to be trained by the center, right? And you are going to work in this central department, income tax department, right? But there are other all India service. We have three all India service, only three all India service are there in India: IAS, IPS and Indian Forest Service. Please remember, Indian Foreign Service is central service. Okay, Indian Forest Service is all India service. So what is the difference? Difference is, although you will be recruited and trained by the center, because all of the people, they get selected through this UPSC Civil Service exam. For IFOS, you have a separate means and interview. Then these people are trained in Missouri, then they go to their respective academies. Now the point is, but in all India service, now they will be allocated cadre, state cadre, right? So although you are recruited and trained by center, but you will be working in a state and you will be working in close coordination with that state government. You're not part of any central government department. Okay, so this is the difference. Now, there is debate also around this concept of All India Service, because some people say that this All India Service is against the concept of federalism. So why this debate? They say that federalism as a concept represents division of power, autonomy of state. But what we have seen in past, that since Department of Personnel and Training at central, union level, it is the actual cadre controlling authority of All India Service. So it means the patronage of these All India Service civil servants lie with center, not with state. And we have seen in past, for example, in case of West Bengal, there was this issue. There was a tussle going on between Mamata Banerjee and union government on the transfer of certain IAS officers. Center was saying, no, we need this IAS officer. And West Bengal government was saying, no, we are not going to allow him to go. We are not going to issue NOC. So this tussle was going on. And at that point of time, the matter was raised, this is against federalism, right? So now this is just basic fact. In 1947, the Indian Civil Service, ICS, was earlier name, was named IAS, earlier IP, Indian Police, now named IPS. In 1966, a dedicated service for forest, in forest service. Article 312, an important article. By use of this article, Parliament can create a new All India Service also. But how it can be actually created by Parliament? We need a resolution passed by Rajya Sabha for that, because we are using the word All India Service, and ultimately the people in All India Service have to go to state cadre, right? So important service which should be made, there has been a recommendation along this point for quite long, is All India Judicial Service. Means there should be a IJS also to actually you can say fill the vacancies in judicial services in a swift manner, but somehow it could not be materialized as of now. I told you All India Service violates the principle of federalism. This is one point, but we should also know what are the positive points. So there are 3 positive points. Number 1, high standard of administration, because all of you, those who are getting actually part of this, getting into the civil service, esteemed civil service, they are going to be trained among the top, you can say, with the top trainers and top services. So high standard can be maintained along all states, right? No matter which state cadre you go, but you will maintain the high standard for which you are trained. Second, uniformity. So one is high standard, second is uniformity. Because if same kind of training, same kind of environment has been created, then definitely you know what is the objective you need to achieve, right? So uniformity. Third is cooperation and coordination, right? Because we need cooperation and coordination in different states in order to achieve our common goals. So if all these people are trained through a common mechanism, then having this coordination, cooperation and joint action would become easier. So please remember these 3 points whenever you have to talk about the positives of this. Okay, now just attempt this question. As when you open this Lakshmikant, you'll find after this public service, you will also find Public Service Commission. Although in your Lakshmikant there's a dedicated portion there, right? Constitutional bodies, there we are going to discuss this, but since it is mentioned here, you should be aware. Appointment, the chairman and members of the State Public Service Commission is done by. Mentioned in your Lakshmikant, you must have read it. Answer. It is talking about SPSC. So please remember that appointment of chairman and member of SPSC is done by governor. Okay, but they are removed by president. This is the twist, and you should know that. Removed only by president. Okay, statement kind of questions are also asked in this manner. Chairman and member of Joint Public Service Commission are appointed by. So earlier we were talking about SPSC, state PSC, governor appoints, removed by president. In case of JPSC, both the work, appointment and removal, this lies with president only, appointed by president. I think it is clear now. Now, integrated judicial service. What does it mean? It simply means that no dual system of administration is there. It means whether it is High Court or Supreme Court, they have to uphold the common laws of India, right? Enforces both central laws as well as state laws. Means High Court cannot say, I am High Court of that state, so I have nothing to do with central law. I'm going to focus only on state law. No, this cannot happen because we have integrated judicial system. Even if you're a High Court, you have to uphold or enforce central as well as state laws. Okay. Parliament can establish a common High Court for two or more than two states, right? So it means Parliament has this power. This is right. Parliament can take this decision. What you should remember, that no state government, state legislature has power to establish their own High Court. Okay. This power is only with Parliament. And this is the structure of Indian judiciary. You have Supreme Court, Apex Court, then High Court. In metropolitan areas, you have metropolitan courts, civil and criminal. In districts, you have district session court. Civil means matter which are related to civil, for example, tax matter, land dispute. Criminal matters dealing with Indian Penal Code, which are considered as offence. These are dealt with criminal court. Criminal court are also known as session court, and judges are considered as session judge, and district court as district judge. Okay. Although at the level of district, this hierarchy is headed by one post, that is district judge, DJ. Then we have subcourts, judicial magistrate court first in class, then principal junior civil judge court, judicial magistrate court second class. Means these judges, judicial officers, are appointed through this PCSJ exam, provincial civil service judicial. Then you have municipal court, means in suburbs, sub areas, there are also, these courts. When we talk about judiciary, we are going to talk about Gram Nyayalayas, Lok Adalat. Everything will be set in your mind, don't worry. Now, attempt this question. The judges of a state high court are appointed by, attempt, come on. President in consultation with Council of Minister and State Governor. Ek to hota galat, ek sarasar. This is sarasar wrong. President in consultation with Chief Justice of India and State Governor. This is correct. Although you should know, the recommendation for name, that who is going to be the judge of a high court, is done by collegium. We are going to discuss collegium when we enter into judiciary chapter. But the word here is appointment, appointed. Appointment is done by President in consultation with Chief Justice of India and State Governor. Okay. I hope it is clear now. Now, how executive relations hamper during emergency. So we have three provisions with respect to emergency. National emergency, Article 352. State emergency or President rule, Article 356. Then financial emergency, Article 360. Right? Now, national emergency. In this case, center can actually direct the state on any matter. The reason is, it may be possible that integrity, unity of India is under threat. So during national emergency, executive power of state can actually be considered that they shift towards center. Direction will be given by center and state has to uphold those directions, right? But you should also know that government is not necessarily suspended when national emergency is in place. Okay, they have to adhere to the directions done by, you can say, issued by center. Then we have Article 56, President sole authority in the state. Now President rule is there, it means now President is actually ruling the state. But President is ruling the state through his representative, her representative, and that is Governor. Okay. Then we have Financial Emergency, Article 60. In this case, center means here President can ask a state to reduce salaries and other expenditures since financial emergency is in place. It means austerity measures can be recommended, and at this point, state government has to uphold that. Okay. So it means a state government is not removed here in case of financial emergency. Now some other provisions. For example, Article 355 imposes duties on the center. Two duties. Number one, that you have to protect state from external aggression and internal disturbance. Second, you have to ensure that state is being run through constitution, means provisions of constitution are protected. Now don't you think Actually, these are the actual grounds. I mean, this is the ground on which Article 356 is imposed. Article 356 is used and President rule is imposed that, oh, the state is not being run as per provisions of Constitution, right? So now, governor of a state is appointed by President. So this is executive power of center, because in this case, President is getting a list, and in this list there's one name. Okay, earlier there's a list, and then from this list, Council of Ministers headed by Prime Minister selects, okay, this name. For example, Rohit. Mr. Rohit is going to be the governor of Tamil Nadu. Now, President will actually, ask, this is the name. I'm verifying it. Now, this person is going to be appointed as governor. My friends, there's no election for the post of governor in India. Governor of a state works on pleasure of President. It may be possible that you are governor of, say, Uttar Pradesh, and the next day you receive a fax that you have to wrap up your things and move out from Raj Bhavan from actually the next day, because now you're not the governor of UP, and now we have appointed a new governor. So you cannot file a case in Supreme Court or High Court or anywhere that how this can happen to me without reason I'm being fired. Aisa nahi hoga, because you work on the pleasure of President. Okay, and President works on the aid and advice of Council of Ministers headed by Prime Minister in this case. Clear about? Now, there's a subtopic within this executive administrative provisions in your Lakshmikant, extra constitutional bodies. So what does it mean? It means this is constitution, and this constitution has certain provisions which talks about center-state relations in executive matter. There can be other ways also, but it is beyond constitution, means it is not mentioned in constitution, it is separate. So this is called extra constitutional. So extra constitutional and unconstitutional are different. Unconstitutional means a particular provision, a particular action is against constitution, but this is not against. It is just that, okay, some themes, some ideas you have done here, but we want some additional means, additional power structure, additional, say, some mechanism. So that is why we are making this. So this is extra, okay, extra constitutional. So who presides over the Chief Minister's Conference? So governor of the state, Prime Minister, okay. So these, now please remember, it is not like you have to cram every article which is mentioned in this part 11 and part 12. What you need to do? You need to just build your understanding as we have done through this discussion. And when you are going to revise important provisions which are highlighted in your MCQs, will themselves they will settle in your mind. Okay, so you need not to worry, just understand the core, the essence of this. This is third video on the same chapter, center-state relations. In previous videos, we have discussed legislative aspect and executive aspect. Today, we need to focus on financial aspect of center-state relations. I personally feel that many students miss on nuances or miss on reading between the lines on financial provisions. And that is why a good amount of trap statements can be made by UPSC in upcoming prelims. Purpose of this video is to save you from those traps. That is why only thing that is required is your attention to me, not me, to this chapter, okay, to this subsection. So let's start. You know that center-state relations are mentioned in part 11 and part 12, and financial aspect are mentioned in part 12. So in part 11, we have already discussed legislative and executive aspect. Those who have not covered, you can go to the previous video. If you have any doubt from any section, you can shoot me a message on shashank.powerbeam. That is my Insta handle. I'll be more than happy to help you out. Now, financial relations are mentioned from Article 268 to Article 293. Okay. Now, we have to talk about tax, and three terms are going to be used in this video: levy, collection, appropriation. What's the difference between these? Levy means imposition. It means, take example, income tax. We wait for the budget day, and we want to see what kind of changes are made on income tax. Why we wait for union government budget when it comes to income tax slabs? Why not a state government budget? The simple reason is power to impose means power to levy tax on income is with center only, not with state. Okay, so levy means imposition, lagana. Okay, now collection. So second power is collection. It may be possible center has imposed a tax, but collection duty is given to state government. So we need to be clear about this, that it may be possible that the same authority, it means center, is imposing as well as collecting, or there can be a difference also. We are going to discuss it, but you should be attentive of these words. These are different. Okay, for example, now we have collected this tax. Okay, this collection has happened. Now the third step, appropriation. Appropriation means decision to actually spend from this collection. To spend. Why you're collecting taxes? Obviously to spend, right? Now, in certain tax categories, appropriation power is with center. In other tax categories, appropriation power is with state. So we should be having clear idea on which kind of taxes state government is having appropriation power. Although you need not to cram all the subjects on which taxes are imposed. Okay, that's not going to give you some cost benefit and in the exam. But you should be clear with the provisions, powers, connection, okay, and the issues from mains perspective. I'm going to give you an idea of that as well, okay, along with provisions. Now first let's talk about allocation of taxing powers. How taxing power is divided between center and state. You are well aware of union list, schedule 7. Now we discussed union list in legislative aspect as well as executive aspect. But why financial aspect? Because certain subjects mentioned in union list are of the nature where tax can be imposed. Okay, so in those matter, Parliament has exclusive power. Exclusive, I'm using the word exclusive power to impose tax. Okay, when it comes to state has similar exclusive power with respect to subjects mentioned in state list. Okay, so with union list, center has power. With state list, state has power. You can see that when it comes to state list, there are 20 subjects on which tax can be imposed. And here in union list, there are 15 in number. Then you should wonder, oh, state government has more subjects on which tax can be imposed. So states must be richer than center. But it is actually inverse. Why? Because matters like income tax, corporation tax, which give huge chunk of revenue to our government, is actually under the ambit of center. Okay, so it is not about number of areas on which you can impose tax. It is about the crucial areas. How many crucial areas are under your umbrella? Okay, so in this you can clearly remember that Parliament actually collect the huge, you can say, majority of the chunk of tax revenues, and that is why Parliament later share this tax revenue with states as well. We are going to discuss it as well, but I think this difference is clear to you. A number state has more subjects. Now, when it comes to concurrent list, on concurrent list, both can impose tax. Okay, obviously, their tax laws should not be in contravention to each other. So both the Parliament state legislature can levy on enumerated and concurrent list, which are 3 in numbers. Okay, now come to residuary power. It means those subjects which are not mentioned in state list, union list, concurrent list. What about those subjects? For example, a new area of business has come up, which was not there earlier. So that is why this was not expressively mentioned, not clearly mentioned. Now, who is going to have power to impose tax on that? Let me give you one interesting example. So you must have seen taxis roaming around in cities, right? And sometimes you see certain advertisement pasted on the outer layer of these cars, right, on these taxis. Do you know this advertisement on these commercial taxis are also text? Yeah. So it means consider that you have a commercial taxi. Okay, you have purchased a car and registered it as a commercial taxi. And now you think that I am the owner of this taxi and I am going to paste an advertisement of, say, your sibling's company. Okay. So, and since you are roaming, your driver is roaming around, consider that your driver is roaming around. So you are thinking no one is going to ask me any tax. But it may be possible that one fine day, the driver's side will be knocked by municipal corporation people that you have to give this much tax to us. Okay. So it means there can be new areas of taxation, right, which are decided, at that point of time when they are discussed. Oh, this is a new area. Okay. For example, taxes on this digital advertisement. UPSC also asked this question in prelims, Google tax. Okay. So residuary power of taxation, that is the power to impose tax not enumerated any of the three lists, is vested with Parliament. So power is with Parliament. If Parliament want to give this power to any other authority, that is Parliament's prerogative. Right? Under this provision, the Parliament has imposed gift tax, wealth tax and expenditure tax. So I hope allocation of taxes is clear to you. Right? Union, center, state, concurrent, both, and when it comes to residuary, center. Okay. Now, so this I have explained you the difference between levying, collection and appropriation. Okay. For example, income tax. Income tax is levied and collected by the center. Right? Levied by the center, because example is budget, right? Our union budget. Collected by center because we have an income tax department which comes under central government. Right? State government don't have any income tax department. They don't have, because they don't have any power to impose tax on your income, personal income. Right? Income tax department is only with central government. Okay. Now, proceeds are distributed between center and state. So whatever is collected, the appropriation, it is distributed between center and state. Okay. Now, restrictions. Restrictions on whom? I'm talking about state. My friends, please give due attention here, because this area many students read superficially, right? But sometimes what you read superficially often actually pop up in your question paper, right? Now, there are three provisions which we need to understand from restrictions. Okay. First, taxes on professions, trades, callings, employment. In general, you can understand taxing on professions. So in some profession, if you are conducting some trade, so one tax is that, oh, I'm giving income tax to the government. States will say, you are giving this income tax to center, not to us. And you will say, but I have read in Shashank Sir's Polity class that the tax proceeds from income tax is distributed with you as well, distributed with states as well. Now state will say, yes, they are distributed, but we are not quite happy with that. And that is why we want to impose a tax on your trade. You will say, what kind of tax? And state will say, tax on trade. Those people who are going to engage in this kind of trade, this kind of profession, which we are mentioning in our law, means law made by state legislature, will be taxed. But there's a restriction over it. This is the old provision, and that is why 2,500 per annum. But you should know, yes, this tax can be imposed, but there's a restriction, limit over it, right? And why this limit? Because you should be reasonable enough to impose the quantum, the kind of tax you are taking from people. Otherwise, people will actually start evading taxes, right? Now, second, so this is quite, direct one, but the trick is there in second and third, and it is quite easy to understand. Just read. Consumption and sale of electricity. Take example that there is an authority, at state level, which is actually selling electricity to center. Now, this law is saying, the provision is saying that if any authority working in state is selling some electricity to center, then no tax will be imposed on such transaction. You will say, oh, center is playing smart here. Tax on consumption sale of electricity allowed, but no tax if consumed sold to center or railways. Railways also come under center, right? So sold to center, if it is being sold to center, then state government cannot impose any tax on such consumption, such sale. Now, you should not misconstrue it like, oh, center wants to take electricity for free. No, I've not said that this electricity will be given for free to center or any department of center. No, I've just said the transaction is taxed as well. Na? The tax is not going to be imposed. For example, you can, after this class, you can just take electricity bill of your home and you will see that there's a tax also added on energy consumption or the rate which is actually charged on you. For example, you have consumed say 1000 units and you are charged 6 rupees per unit, okay, 6,000 rupees. Apart from this, there's charges like, okay, you have 6 kilowatt, connection, then there's a charge say 500 rupees. Now total amount seems to be 6,500, but you will see there's additional tax imposed there. Then the tax I'm talking about, that tax cannot be taken from center. Okay, in this transaction, that tax is not going to be used if it is being sold to center. Okay, one thing is clear, sold to center. Now, there's a twist in the third provision. Consider that there's a central government body, for example, NTPC. Okay, so NTPC is a PSU responsible for generating electricity. So PSUs are working in different states, right? Now, if this PSU is selling electricity to some entities, now can this transaction will also be exempted, or state can also impose tax on this transaction? Let's understand this. A state legislature can impose tax in respect of any water or electricity stored, generated, consumed, distributed, or sold by any authority established by parliament. That is why I gave example of NTPC, right? Power Generation Company of Center, right? Unit of center. So now this third provision is saying that if there is any central government body which is engaged in say water, electricity storation, generation, consumption, distribution, then state can impose tax. So here the word is sold by. Earlier it was sold to. No tax can be imposed if center is taking electricity. But if central government body is selling electricity, then state government can impose tax. Now some of you would say, sir, you said restriction on state. Then how this can be considered as a restriction? Restriction hai. Take a look what is written here. Means this can be done, but such bill need to be reserved for the president. Should be reserved for the president's consideration and receives his assent. So it means a state government can impose tax on such entity, that we want to impose tax on NTPC's transaction to different bodies, okay, because we want to use this tax to actually upkeeping or developing the interstate river and river valleys for developing. Because if you are generating say hydropower electricity, so state has responsibility to actually do the upkeeping work, development work around this river valley. So from where you have to do it? From where you can do it? So you can do it from the additional tax which you are collecting from the central government bodies. Okay. So now you can easily remember it. Number first, it was tax on professions, but there's a limit here. That is why we are saying taxation. Second, any electricity which is sold to center is exempted from tax. State will not impose tax. Third is when central body itself is selling, yes, here tax can be imposed. Sold by, tax can be imposed. Okay, but this bill need to be reserved for president, and after president assent, then it can be cleared. Okay, so I hope these three restrictions are clear to you, right? question can be expected. Now, distribution of tax revenue. So there was 18th Amendment Act 2000 mentioned in your Lakshmikant. Purpose of this amendment was that it enhanced the level of corporation tax and custom duties at par with income tax. So you will see what bought several central taxes at par. What does it mean? What is the meaning of at par with income tax? Let me explain this to you. In earlier slide I told you income tax proceeds are levied, collected by center but distributed between center and state. It is confirmed to you, right? Now, with respect to corporation and custom duties, same is going to be done. That was the mention, you can say that was the provision of this 18th Amendment Act, Constitutional Amendment Act. What does it mean? It means now states are going to get share from corporation and custom duties as well. These are such taxes which are levied and collected by center but distributed with states now after this amendment. I hope it is clear now. Now, moving to the next amendment, the most popular one, 101 Amendment. We are talking about GST tax. So GST has simplified the indirect tax structure in India. When I say indirect tax structure, means I'm talking about taxes imposed on goods or services. So it replaced many indirect taxes, tax on final goods. Okay. Now, there may be a question on which of the following ways represent the tax powers or established between center and state. Okay. So you need to understand these areas, means how tax is handled between center and state. You just need to remember it. First case, tax levied by center but collected and appropriated by state. Means center is imposed but given responsibility to state. You collect and you appropriate. You take decision on actually spending it. Stamp duties on bills of exchange, check, promissory note, insurance, transfer of share, excise duties on medicines. So although indirect taxes are being subsumed under GST, you need not to cram the areas on which this scheme of sharing is imposed. Okay, you need to understand the provision. Clear? As I told you, cost benefit, we need to keep in mind the amount of time you spend and the amount of marks you can actually gain in exam. Now, taxes levied and collected by center. So here you have two cases with center. Earlier you were having just one case with center. Now two cases, levied and collection by center and assigned to the state. Please remember, I'm focusing on the word assigned. Assigned means now it is given to state. We have imposed, we have collected, now given to state. You actually appropriated. So tax related to interstate trade, commerce, interstate trade. It means tax which is going on if one thing is actually being produced in one state and it is being sold in other state. For example, say one sari being manufactured in city of Surat, Gujarat, and it is being sold in Madhya Pradesh, UP or any area. So this is interstate trade. So any tax which is imposed on interstate trade will be levied and collected by center, but will be assigned to state. And in this case, after the coming of GST, this is shared between these states. Means center will say, no, I am just imposing and collecting. This is going to be divided among you. Okay, this is second formula. Third, taxes levied and collected by the center. Levied and collected by the center. It is same as the second point, but twist is in this distribution thing. It means distributed between center and state. Imposition we are doing, collection we are doing, but this tax is going to be shared between center and state. For example, taxes and duties referred in union list. So the taxes which are imposed and collected by center, because these are exclusive power of parliament, then these are actually shared with state as well. Okay. Now distribution of non-tax revenue. First of all, what is the meaning of this non-tax revenue? Tax you understand, right? Binding, amount which need to be paid by people to the government, right? But what is non-tax? Non-tax is, for example, fees. Means giving tax is your responsibility, that you have to give tax, right? But for example, fine. Now tell me, is it your responsibility to give fine challan to the government? No, right? So it means fines, profits. Yeah, governments also have profits, right? PSUs through government companies, right? So fines, profits, these are example of non-tax revenues. And state government and central government, they collect a lot of fines and lot, you can say, different revenue streams of profits as well. They have profitable ventures, right? So now in this aspect, they have to deal with their respective list, means the areas in which you can actually impose, you can collect that are yours, right? So a quite independence in this area of non-tax revenue. Now coming to grants in aid, what is the meaning of grant? And is it different from loan? Yes. When loan is given, it is expected that you are going to pay me back under these conditions, maybe interest. But grants are, I have given you this amount and I don't want this amount to be back. Just take it. So why I'm giving you grant? To chill? No, I'm giving you this grant so that this can be spent in specific area. For example, for development purpose. So there are two kinds of grants. One are statutory grants. The word statutory itself represents law, act, right? So Article 275 says that there are certain grants which need to be given by center to the state. It means are given to the states on recommendation of Finance Commission. It means you have to do this. There's no way out, right? But when it comes to discretionary grant, as the word discretion says, Article 282, it says it is discretion of center. If center thinks, yeah, this particular state is having these financial crises, this particular state need to spend more on education, health, or develop, other areas of development. So there, center can actually give it from its, its own side. It is not on the basis of Finance Commission's recommendation, right? So there's a difference between the two. Now there are other grants as well. So one is grant in lieu of export duty. What does it mean? You can take example. For example, a state government wants to increase manufacturing and export in its area. And earlier, this state government used to take some export duty, right? If you're sending these things, then you have to give this particular tax. Now, center might say that, okay, in this area, there's good scope of production. Why don't you give rebate to the people who are investing in your area so that they can easily manufacture? Taking rebate from you, they will be able to sell this product in some other country or some other area on cheaper rate, or you can say on a better rate. If it is being sold on better rate, then there will be high demand, and if there's high demand, then there will be more production in your area, more people will get jobs. Fair deal, right? But it may be possible that state is dicey. State will say, oh, this is going to create revenue losses for me. So in this case, center can come into actually picture and they can compensate. Oh, we are going to give you grant. Okay. Now coming to Finance Commission, Article 280. Finance Commission is a constitutional body. Mentioned in our constitution, it is a quasi-judicial body. Not having full judicial function, but having quasi-judicial power. Although many people question, we have not seen any work of Finance Commission where Finance Commission is acting as a judicial body. Why are you saying it is a quasi-judicial body? My friends, such status was given to it by Constitution, keeping in mind that Finance Commission is going to decide on or give recommendation on division of proceeds, these grants between center and state. So it may require an area where other states will actually come on Finance Commission and say, these are my grievances, this formula is faulty. So in that context, you have to work as a judicial body also, quasi-judicial body. Okay. Now, it is responsible for giving recommendation on two areas, chiefly, means mainly. Number one, distribution of tax proceeds, total proceeds between center and state, and number two, it also gives recommendation on supplementing the resources of state for Panchayati Raj and local government bodies. Okay, that is also prerogative. Please remember, we are talking about Finance Commission, the central body. Augment the consolidate fund of the state. It can give recommendation to the state how you can augment, improve your financial status, how you can supplement the resources of the panchayats and municipal bodies. Okay, important point. Clear? Now, protection of state's interest. What does it mean? Means if Parliament is not actually having any limitation on its power with respect to changing the tax proceeds or varying or adding any tax, then it may actually negatively impact the interest of state. So we need to have certain protection there. So one is imposing and varying. Imposing means to impose something new. Varying means there's already a tax, but you are varying that, in which states are interested. It may be possible in a particular area, center has already imposed a tax, but center has varied this tax in a manner that industries in this area are going to be negatively impacted, and which is going to impact the other tax proceeds or interest of that state. Don't you think this is a valid argument that state government will say, although you have varied this tax, but the future of my area, my government, although whole is India, but I am also responsible for development. So my resources are going to be impacted due to your variation, right? So in this case, it is said that prior permission of president is required before actually presenting this bill in Parliament. Okay. Although it is said that this is not that much security cover, because president has to act on an advice of council minister, and if council minister has decided, because ultimately government is having power to actually vary this tax. So if they have resolved this, then how can actually president stop it? But this is you can say a layer, additional layer, so that if prior recommendation of president is added, it may be possible that president from its own side, since it's a layer, can actually bring some insight on this issue, that there can be possible ramification for this also. Varying the meaning of agriculture income. As you know, agriculture, prerogative of state. So if you vary this, it may hamper the state interest. Impose any surcharge, additional charge on any specific income category or area. So in this case, president's prior recommendation is required. Okay, please remember these three cases. Now, borrowing by the center and state. Now, if I ask you, from where our government, be it center or state, get funds, arrange funds to be spent on these developmental activities and daily activities, salaries and other expenditures. So you will say, sir, one thing is, when it comes to state government, one source is their revenues, tax revenues. Other may be non-tax revenues. Third may be grants, which they are getting from center. And fourth are borrowings, right? Means taking loan. Now center and state both can take loan. One thing should be clear. Now the point is loan from inside and outside. So answer is that center is allowed to take loan from inside, means our own banks or banks working in our territory or other financial instruments, or from outside as well. And Parliament is there to fix a limit on this. But as of now, there is no law made by our Parliament to put a limit on the borrowing capacity of a center. So you can read, central government, state government can borrow either within India and outside. Not abroad for state. Here I have mentioned the word D. It means a state government cannot borrow from other areas directly. For example, Uttarakhand government took loan from Asian Development Bank, ADB. So this loan was actually, cleared because central government was there clearing this file. Yes, you are allowed to take this loan. So it means state cannot take loan from abroad on their own. Center's role becomes mandatory. Okay, within the limits fixed by Parliament, state legislature. When it comes to limit, limit can be fixed by Parliament, state legislature. No limit so far as I told you, no law has been made. A state cannot raise any loan without the consent of the center. And the reason is, it may be possible that a state government has already taken loan from center. And now state government is taking loan from other central government body, say RBI. So central government will say, you have already taken loan. Why you're taking additional loan? Just tell us how you are going to repay, how you are going to maintain your sound financial balance. So that's why this provision has been added. And my friends, this particular issue becomes more important, especially in this pandemic time, because states have said that our primary source was revenues collected from state and different tax proceeds. But due to you can say downturn in our economy, due to these lockdowns, the tax revenues have actually soaked up, right? Second is this grants. But central government has not given grant in this pandemic period due to this financial issue with the center as well. Now, what is the third source? Borrowing. So states have said that our borrowing limit should be increased. Now, my question to you, what is the borrowing limit of states as of now? Just mention in comments. Do you know a particular law which sets borrowing limit of state? Come on. FRBM Act, Fiscal Responsibility and Budget Management Act, 3.5% of the state's GDP. That's a maximum limit that state can borrow. Although this limit can be changed in special circumstances by Indian Parliament. And that is why this point was raised, that it is valid to raise it now, because these are extraordinary times. We have not expected such downturn. Now, intergovernmental tax immunities. It means immunities where center should not impose tax on state and state should not impose tax on center. Just give this attention here, because this area is also like students actually just turn the pages, but I feel that there can be a question. First, Parliament empowered to remove this ban. It means there's immunity, but Parliament can actually make a law and say, I don't want this immunity in this area. State, you can actually impose tax, but you know that this is not going to happen. Now, property may be used for commercial and sovereign purpose. It means central government department is having some property, okay, in state, obviously. So now they may be conducting some commercial activities there. Means central government company has made some shops there, right? Doing some business there. So can state government impose tax on such property since it is being used for commercial purpose? No. For sovereign purpose? No. Right? It means this is a immunity. And it is quite easy to remember for you. Same kind of immunity is available to state government. The state government is also saying, we are having this property, say in Delhi, and we are using it for, say, commercial purpose, say Andhra Bhavan, Gujarat Bhavan, right? And we are having these canteens there. People are flocking for delicacies, but you cannot impose tax on us, right? This is an immunity there, okay? Corporation companies, if central government has some corporation companies, so they're not immune from such taxation. State government can impose tax on them, okay? Now, when it comes to exemption on state, means of state from center, please remember there are 3 points. First, ban can be removed by Parliament themselves. Second is commercial sovereign, kaisa bhi use kare, no taxation by state, okay? Corporation companies, tax can be imposed, no immunity. Here, property may be used for commercial sovereign purpose, same. State is also having this immunity. Second, if Parliament provides commercial function, may be taxed. It means if Parliament itself has provided, has supported state government to have this business, sustain this business. So it is like now Parliament will say that it is not your own business. We have also partnered in that. Since we have also partnered in that, we want to actually impose tax. So this can be done. Center tax or income local authorities. So central tax property or income of local authorities. So local authorities can be actually exempted. Means they are having immunity. And immunity from central taxation. Okay. Corporation companies, they are not going to have immunity. Okay. So I hope this is clear. Now, effects of emergency. What is going to happen? Number one, President can actually reduce or cancel the promises which were made by center to the state. We are going to give you this much tax proceed. Now we are not giving. We are going to give you this much grant. Now we are not giving. So it means this can be done in case of national emergency. Second, such modification continues. Now this is an important twist. UPSC will make a statement when national emergency is in place, financial relations between center state are going to be changed, and consider the giving of grants has been shelved now, or sharing of tax proceeds have been shelved. Now they are going to make some words they are going to use, like this particular provision will cease to exist after 6 months from the removal of national emergency. Now, since you have read this clause, this particular phrase, that this particular law is going to be applicable only till 6 months from the cancellation or removal of national emergency. So that is why sometimes students actually link this with everything, but that's not true. Okay, in case of financial aspect, this particular provision that like president has cancelled or reduced, this will remain in force till the end of that fiscal year. Such modification continues till the end of that fiscal year, financial year in which the emergency ceases to operate. So consider that emergency ceases to operate in, say, January 2022. But this fiscal year, financial year, is going to continue till 31 March. Right? So now states will not say, oh, now it has been shelved in January, so from February we want the due of our tax proceeds. You cannot say that, because it is going to continue till end or cease of this financial year. I hope it is clear. That's why I've put star point here. Financial emergency is imposed. What is going to happen? Then center can say, you have to ensure the canons of financial propriety. It means save wherever you can. Second, reduce salaries, allowances of every class of civil servant, means government employees. Along with this, including high court judges, because we are talking about state, right? To reverse all the money bills and the other financial bills for the consideration of president, to reserve. If you want to make some bring some money bill, because we are already in financial emergency, that you have to reserve it. Where president is going to see whether it is fine to actually continue that or not. Okay. In our previous 3 videos on this chapter, center-state relations, we have covered legislative, executive and financial aspect. Today we need to discuss issues between center and state, commissions which are made in this regard, and what were the prominent recommendations. This section is going to give you good fodder point for your prelims as well as mains. So let's talk about trends, means the issues between center-state. Were they prominent in 1950s and 60s also? No. Till 1967, the relations were quite smooth. And the reason was, Congress party was having hegemony. In center there was Congress, in states there was Congress. And as we saw that many states got non-Congress party leading the government and Congress at the center, then conflicts started emerging. Now you should think, was center-state relations got a downturn, or why we are saying downturn? Because conflicts started emerging. Is it due to some political differences, or this is more than that? Because being a UPSC civil service aspirant, you should know that we are more interested in understanding the provision part, what constitution says, what federalism as a concept says. And on this premise, we are going to decide what claims which are made by states are legitimate and what are just mere for political gains, right? I hope you will agree on this point. Now, what were the tension areas? Number 1, governor's appointment. You know that governor is appointed by Honorable President on the advice of Council of Ministers. And this governor works on pleasure of President. It means can be removed, transferred at any point of time without giving any reason. And that is why it is said that this governor works for central government. Allegations are made. So now government's appointment and dismissal and role, it is questioned by state. The state says governor is executive head of the state, but governor works as agent of center. This is against the principle of federalism. Independence of state is being compromised. Second, president being partisan. Several, there are several occasions where governor reserve a bill for the honorable president, and sometimes this bill gets stalled, which actually hampers the legislative power of state. Another issue is central armed police forces. Means states say that many times center enforce, or you can say send forces, central armed police forces, without consultation with state. It actually questions the legitimacy of the role of state. If state government is confident enough to manage the law and order, then central government should not intervene by sending these forces. That is one apprehension. Another is bill. As I told you, state legislature presented a bill to governor. The governor has sent this bill to honorable president. President has a lot of, you can say, powers with respect to passing, giving assent to this bill or stalling this bill. Discrimination in financial allocation. So there are two apprehensions from financial aspect. One is when this division of revenue is done between center and state on the recommendation of Finance Commission, although Finance Commission recommendation is not binding, but it has some value. So state says we get lesser share of revenue and we have more expenses than center. When I say more expenses than center, it should be considered in proportional manner. Means areas in which a state has to spend. I'm not talking about the quantum. Sharing of finances. So they question that a state should have more funds from the revenue which are collected by center. The state says we should be given more liberty to make our own policies, because one size fits all won't work for everyone. A policy can work good in, say, Bihar, but that policy won't be, it may be possible that policy won't work that well in Himachal Pradesh. States should be given more funds. They can decide the developmental model they want to adopt. Management of all India services. As you know, IS, IPS, Indian Forest Services. There are 3 all India services. States time and again says that these all India service have patronage towards center, which compromises the, you can say, authority of state government. That is one claim, and in upcoming discussion you will see how many times various you can say commissions which were made by state on center state relations have demanded abolition of all India service. Abolition. Now, use of electronic media for political purpose. It means you must be knowing Doordarshan, All India Radio. So it means these are institutions, prominent channel of communication, although they're not that prominent as of now. But think of the time, we are talking about 60s, 70s. They were the prime, you can say, connection between people and the government, or what is happening around the world. So states were saying these channels were actually used by a party in the power in center for their own political purpose, own political gain. That is wrong. Appointment of inquiry commissions against many chief ministers to actually arm twist them. Encroachment on the state list. So you can see these are the prominent, you can say, tension points between center and state. So I asked from you just 5-6 points, and now you have more than that, right? Now, commissions and initiatives which were made. So now, with respect to commissions, we are going to divide them into 2 parts. Commissions which were made by center, commissions which were made by state. Means state making commission, giving recommendation to center that you should adopt it. Okay? And then we are going to talk about, within the center part, we are going to talk about Sarkariya Commission, Punchi Commission at the last, because they are the most important. We are going to start with ARC, Administrative Reforms Commission, which was headed by Mr. Morarji Desai. So this commission was made to actually look into the issues which were raised by state, whether they are legitimate or illegitimate. If something can be done in this regard, then this commission was given responsibility that you should recommend. So there was a separate study team under MC Setalwat, who was once Attorney General of India. So now what were the recommendations? There were 22 recommendations, and out of them major recommendations are these. Now please connect these recommendations with what we have discussed until now. Okay, first recommendation, establishment of interstate council, non-partisan governor. I told you number 1 point was governor issue, and first ARC was recommending non-partisan governor. Governor should not be someone who has political background, which is the culture in present time. right? All politicians are given this responsibility of governor. Delegation of more power to states, more financial resources to state. I think now you are connecting. State demands were being addressed by ARC in these recommendations. Deployment of central forces. They said central forces are being deployed without our consultation. Now they're saying on request of state, right? They should be actually, you can say, deployed. Or if there's emergent circumstances, then only this should be deployed by center unilaterally. But whether some action was taken by government on these recommendations, no action by government on this ARC report. Thereafter, we saw Raj Mannar Committee. Now, this was not a committee which was made by center. This was made by Tamil Nadu government. 3-member committee. So now see the recommendations which were made. Setting of interstate council. You will see similarity. Interstate council was demanded. Here also interstate council was demanded. Permanency of finance commission. Then you should question, why permanency? First of all, you are well aware that finance commission is a constitutional body, right? Established by Honorable President for a term of 5 years or maybe early. Means there is no fixed tenure of finance commission. Okay. Now, finance commission is not having some permanent secretariat. It is given a list which we call term of reference, that on these objectives you have to work and give recommendation to the government. Now after these recommendations are given, job is done and then it can be quashed. Now state said, our future is decided on the basis of recommendation made by finance commission with respect to finances, sharing. And if we have certain apprehensions on the formula that finance commission has used, where should we go? There's no permanent secretary, a dedicated secretary to finance commission. This is a constitutional body, but not permanent body. Make it permanent. So that's why they raise this, so that they can raise their grievances at this stage, right? Disabandonment of planning commission. Why? Because planning commission was not involving states while deciding 5-year plans. Omission of president rule means they were saying, let's remove this article 356 usage because it undermines this concept of federalism. Many times state governments are removed just for political gain by the party in power at center. Residuary powers to state, and now you will see this demand has been consistently raised, residuary powers to state, by other commissions as well. Okay, the residuary power means subjects which are not mentioned in unions or state list or concurrent list. In these regard, who has the power? Parliament has the power, right? Parliament is supreme in this regard. They said no, state should be made supreme. Abolition of all India service. Abolition, removal of all India service. They said we can actually, every state government can work with the provincial civil services. We don't need all India service because all India service people, they're appointed by, on the recommendation of UPSC. Cadre handling authority is DOPT. Later it was DOPT. Earlier there was service, there was an integrated department for services. So now they said patronage lies with center. It is undermining the authority of state. So abolish it. Okay. So now, was any recommendation of Raj Mannar committee accepted? Now see the quantum of change they were asking. Remove president rule, remove all India service, abandon or disabandonment, just remove planning commission. So what central government did? Central government smiled. Okay, let's see. So central government completely ignored the recommendations. Okay. Now second is Anandpur Sahib. This was again a commission which was made by a state, not center, right? Punjab. And it has two objectives. One was political, other was religious, considering the context of Anandpur Sahib. Now, they also asked residuary power should be given to state, as was asked by Raj Mannar committee. Equal authority and representation to all state. What does it mean? Take example of US Senate, right? And equate it with Indian Rajya Sabha. India's Rajya Sabha, the number of seats allocated to states are based on population, and that is why seats vary from 1 to 31. Uttar Pradesh is having maximum seats. Why? Because of the population. Right? Now, they said we should follow the formula of US. Each state was given 2 seats. That is why 100 members for 50 states. So that was their demand. Then they said this was one of the radical, you can say, recommendation on center-state relation by Anandpur Sahib. They said center's jurisdiction should be limited to only defense, foreign affairs, communication and currency. Every other power should be left to state. So it was like making center weak. And that is why you can easily remember that this recommendation was not accepted. This was like changing the Schedule 7 of Indian Constitution. They were saying change this union list, state list, concurrent list. Then came Bengal, West Bengal Memorandum. So this is the third commission which we are discussing from state part, and before that we have discussed ARC, first ARC recommendation on center-state relations. Clear? Now, what they said. Now see the commonality. One common thing is clear, residuary power to state. All three have demanded residuary power to state. They also asked that the word union in our constitution should be replaced with federal, so that states can truly enjoy the independence, the autonomy of the concept of federalism. Presidential rule and financial emergency to be repealed. Means just remove Article 356, just remove financial emergency Article 360. Consent from state for state reorganization means whenever you are going to use Article 3, then consent of state should be mandatory. As of now, it is not mandatory. Although this bill is presented to the state legislature, but their recommendations, their apprehensions are not binding on the center, right, on the parliament. Rajya Sabha should be equal to Lok Sabha. As of now, we know that Lok Sabha has more power in most of the cases. That we are going to discuss in detail when we are going to discuss Parliament chapter. 75% of the revenue to state. Or if you are collecting 100 rupees, then 75 should be distributed in state. Abolition of All India Service. They are also asking abolition of All India Service. And now you can connect why state governments have so much apprehension for All India Service and the level of apprehension they have. That's All India Service is going to have inclination towards center. So central government did not accept the demands. So it means whether we talked about Rajmannar, Anandpur Sahib resolution or West Bengal memorandum, center did not accept it because they were demanding far-reaching changes. They were demanding structural changes in our constitution, right? So now Sarkaria Commission was made under Justice R.S. Sarkaria, and look what he suggested. He said we should not do the structural changes in constitution. What we can do, we can actually change some functional aspect. Operational aspects can be changed. The way we use these laws, this needs to be changed. If governor position is being abused by party in power center, then let's make a rule regarding appointment of governor. If you are seeing that many times state bills are being stalled, then rather than actually taking all the power from the center with respect to this particular process, let's do one thing. Let's make government more responsible whenever president stalls a particular bill, right? So it means Sarkaria Commission actually adopted a balanced approach. Let's discuss one by one the recommendations which were made. Interesting one. They said ISC means Interstate Council should be changed into Intergovernmental Council. President rule should be used rarely, means in utmost necessity. All India Service to be strengthened. So everyone in these three commissions, three means I'm talking about Anandpur Sahib and Rajmannar and West Bengal Memorandum. They were saying abolish All India Service, but Sarkar said no. All India Service should be strengthened, and there should be more All India Service. Like IS, IPS, IFS, we need more All India Service. Residuary power, they were saying residuary power should be given to state. They said no. Residuary power should be concurrent, means in such matter both can make law, but when it comes to power to tax on something which was not mentioned in all the three lists, it means residuary power with respect to tax, that should be with parliament only. That is what Sarkaria was saying. Reason for withholding. If you withhold a bill of state, then give reason to that state. There was NDC, National Development Council, it should be turned into National Economic and Development Council. The work sphere of this council should be more specific and elaborate. Zonal council should be reactivated so that disputes between states can be resolved at this level. Center should consult states before making law in concurrent list. I hope you're connecting. This was the apprehension that center tried to actually overpower, right? So they are saying if you're making law in this concurrent list, consult states. CM consultation before governor's appointment, because governor has to work in close coordination with CM, so CM's recommendation should be accepted. Sharing corporate tax with states. So in this regard, we already discussed in the previous video. 80th Constitutional Amendment Act was made, so that a scheme of sharing taxes was actually made at par with income tax with respect to corporate tax and custom duties. I discussed this. Council of Ministers having majority. If Council of Ministers is having majority, governor should not disband the government. Okay, because many times governor disband the government and asks for disbanding a government even if this Council of Ministers is having majority in state legislature. That is wrong. That is a fraud to democracy, right? Because people have elected him. Expect compelling reasons or dismissal of governor. That governor is removed without giving any reason. It should be given some reason. He should or she should be given some reason. Inquiry commission against ministers can be actually made by the demand by parliament. As I told you, there was apprehension that many times CMs and ministers at the state level, inquiry commissions are made by center. So this can be done when parliament made such demand. Surcharge should be in specific case and for short term. And 3-language formula was suggested. You know that in center and state there was apprehension that center is trying to enforce Hindi forcefully, right? And the languages, Hindi was the main reason. So Sarkari Commission recommended 3-language formula. So what does it mean? It simply means that 3 bases should be there whenever language policy is made at the state level. Group identity means the language should be such that people can connect with that language. Second is national unity. National unity is a priority and language is the thread which actually weave people in. Third is administrative efficiency. That should also be the criteria. So please remember, this was the good recommendation which was made by Mr. R. Sarkaria. So out of these 247 recommendations, 180 recommendations were implemented, including the establishment of interstate council. Don't you think it is a major achievement in the picture of center-state relations in India? Right? That is why I was saying Sarkari Commission is important. Now after that, Punchi Commission was made, 2007, under Madan Mohan Punchi, former CJI. And now you will see that Punchi Commission discussed some new issues. And whenever a question is being asked on center-state relations, your understanding of Sarkaria and Punchi Commission will give you more than enough points. You will have good amount of points. Now here they discussed, we need to discuss issue of communal violence. Yeah, means how center and state should coordinate on these issues. Interlinking of rivers. If devolution of powers and autonomy to Panchayati Raj institutions, right? Independent planning and budgeting at district level. Don't you think these are important issues, right? For development at ground and how center and state should actually play their role. Central assistance versus performance of state means assistance is given. States have demanded 75% fund should be given to them. But now Punchi Commission said whether funding should be based on performance. If states have performed well, then they should be given some additional funds so that other states can also get inspired and their administration also work better. Positive discrimination should be also there with respect to some state. It means if some states are lagging behind, say in education, drinking water, basic things, then center should support them more. Tax and VAT regime, although now we have GST, but the kind of VAT system should be adopted so that the trade between different states can be at ease. Integrated domestic market should be established. So it is linked to this. Central law enforcement agencies should actually get into this picture of crime, investigating crime when a particular crime is having ramification on its interstate. Means more than one state are getting impacted due to some case, then central law enforcement agency should have power. So these were the issues, term of references on this, on which it was asked that Punchi Commission, you should look into these issues and recommend us. So now 310 recommendations were given by Punchi Commission. Number one, they said there should be broad agreement between center and state before legislating any matter on this concurrent list. Issues on concurrent list have broad agreement. And I hope now you can see a commonality between what Sarkaria was saying and what Punchi was saying. Sarkaria said, consult center. Center should consult state whenever a law is being made on concurrent list. And Punchi said, this should be done. Restrain parliamentary supremacy in state list. You know that there are cases where center can make law in matter of state list also. So there should be restriction of supremacy, right? It should be done in extremely necessary circumstances. Interstate council to audit concurrent list, whether it was needed to make such law on concurrent list by center only, whether this can be actually delegated to state as well. Interstate council should do the audit. 6 months should be given to the president when a matter, means state bill, is before president, so that a state's necessity to actually turn a bill into act can be taken into consideration. Follow Sarkari recommendation on governor selection. What was the Sarkari recommendation on governor selection? Just tell me. I've just discussed. Come on. I've just told you. Since governor has to work in close coordination with CM, so CM should be consulted while appointing any governor in that state, right? Governor removal should be by impeachment. As of now, you know that governor can get a fax from the president house that now you are not governor, you should pack your things, and no reason will be given. No reason is mandatory. So now it should be like impeachment, so that governor's position can get some kind of security and governor can work in an independent manner, not just agent of the center. Governor's discretionary power to be exercised in non-arbitrary manner. As of now, a lot of discretionary power are with governor where no question can be asked. Governor can use this because there is ambiguity on those provisions. Prominent being with respect to when hung assembly is there. You must be knowing about Goa case, right? In 40, I'm talking about the previous elections in Goa, right? When BJP government was formed, when BJP got 13 seats, the seats needed for majority were 21. Congress got 17 seats. So Congress needed only 4 MLAs to prove majority, and this Congress and this BJP needed 8. So, but BJP actually found success. Mridula Sinha was governor at that point of time there, and she was connected to BJP earlier. So, some kind of allegations like this are made that governor works in partisan manner and give opportunity to the other party, the party in power in center. Now, decide about the bill in 6 months. Governor should also decide about the bill in 6 months. Constitution to lay down guideline. For example, the hung assembly case, this I told you. When there's hung assembly, it means no party or coalition is getting clear majority. Then who should be given first preference to prove majority? So there's ambiguity there, and that is why governor works in arbitrary manner. Although Punchi Commission said that pre-poll alliance should be given the preference, means alliance of parties which was made before election, right? Governor have the right to sanction prosecution of a state minister. Governor only constitutional role. Governor should not have a role of chancellor and have some statutory position other than this, right? So this was recommendation of Punchi Commission. Apart from this, you know, imposition of president rule is prominent issue between center and state. So they said restrict the use of Article 56. Although we have one important case in which Supreme Court gives the guideline that we should use, means center should use Article 356 sparingly. Can you mention that case in comment? Come on. Case with respect to misuse of Article 356. Come on. Rapid fire round. Name of case is Bommai case. Please remember. Framework to deal localized emergency. For example, if there is some emergency like condition in an area, there should be framework to deal with that condition there only. It is not necessary that you use Article 52, 356 and get more power to center. Right? If an issue can be managed, then it should be managed easily. And Article 263 should be amended, which talks about interstate council. And amended in which manner? Interstate council should be given more power. It should be it should be made more credible. Because if I ask, have you ever heard about some major achievement of interstate council? Then you might look towards your fan or around. याद तो नहीं आ रहा है. Why? Because we have not, discussed. We have not. This particular body has not been in news for some achievement from many years. Zonal councils to meet 2 times at least per year. For example, government has made this empowered committee of finance ministers so that issues with respect to VAT uniformity between state and better trade between state can be ensured. So they have achieved considerable success by this formula. So Punchi Commission said similar kind of empowered group of ministers can be made in other areas as well, right? Although now we have GST. There should be forum of CMs so that they can coordinate on policies in matters like energy, food, etc. If some state has surplus energy, then it should be given on fair terms to the state. If there is some food scarcity and other state is having food surplus, then it should be managed. New All India service should be made. Now see the commonality. Sarkaria Commission was saying All India service should be strengthened and more All India service should be there. Similar kind of recommendation is made by Punchi Commission. They said there should be All India service in case of health, education, engineering, judiciary. Removal of obstacles for well-functioning of Rajya Sabha and equality of representation respect to population size, means the US model, the CNET model, US Senate model, which I discussed. Devolution of power to local bodies. Now go through the term of reference which I said, means PRI was an objective of term of reference on which Punchi Commission was asked that you should give some recommendation. They said more power should be given to local bodies, right? And when state governments are given responsibility, yes, you should implement the central law. Then if they are implementing the central law, then they should be given more funds. Means cost sharing should be there, right? And when it comes to central government PSUs harnessing, exploring, extracting some minerals from a particular state, so state is given some royalty. So there are 2 issues in royalty. Number 1, that this royalty is not renewed in a particular interval of time. Same royalty is continuing for so long. Second is the amount of royalty is many times delayed and state government has to manage its finances. So now Punchi Commission said that it should be renewed on timely basis like 3 years, and if there is delay in funds, then interest should be paid by the center to the state, right? When it comes to professional taxes, in previous video when I was talking about financial aspect of center-state relations, I told you that professional tax can be used by state, but limitation is not more than 2,500 per annum. So Punchi Commission said no ceiling should be there on professional tax. Assessment of all fiscalizations by independent body. If there are some fiscal, with respect to, when I say fiscal, it means I'm talking about 2 things. Number 1, imposing of taxes, means revenue collection, and number 2, expenditure. And since fiscal policy of center is going to have impact on states as well, that is why there should be an independent body to actually assess these fiscal, you can say, fiscal related bills. Mechanism to involve states in finalization of terms of reference Finance Commission. As I told you, that Finance Commission appointed by President on the recommendation of Council Minister, and term of reference means agendas on which Finance Commission is told that you have to work and give recommendation. So there, state participation is missing. So they said state participation should be there so that states can also put forward their points. Fair, you can say recommendation. Now bring down surcharges and cess charges. Permanent Secretariat for Finance Commission. Reason, I told you. So that these states can reach out to Finance Commission. On which basis you are given this recommendation? We have these points and these are valid points. Please consider that. So this should be made, right? Interstate and Commerce Commission should be established under Article 309 as a constitutional body, so that interstate trade and policy can be more, you can say, uniform, which is going to benefit all. So I hope now you are clear with the recommendations of Punchi Commission. Center-state relations pay, no matter what question is asked on commissions, it will be far easier for you. It will be cakewalk for you to actually answer it correctly. When questions are asked in mains from center-state relations, just go through this video again, have a pen and paper in front of you or a Lakshmikant, underline things, and it will be easy, cakewalk to understand these. Okay. Apart from this, I've added some MCQs in this PDF. After you go through this video, I'll ask you to go through this PDF This PDF will be uploaded in this Telegram group, Shashank Tyagi for you, tonight, and you can actually go through this MCQs and attempt them. Solution is also given. Those who have some doubts with respect to any lecture or any part of your preparation, you can shoot me a message on shashank.powerbeing. That is my personal Insta handle, and I'll be happy to help you out. See you in the next video. Till then, keep learning, keep growing.